This is No Hate Radio.
I'm no stranger to the rain. Oh, no. I'm no stranger to the rain.
Welcome to another episode of No Hate Radio. We will try today to expand on our series that we're starting and working on, and it is a work in progress, on the political landscape in America today. Today's particular subject is the United States Supreme Court, sometimes referred to as SCOTUS, S-C-O-T-U-S, Supreme Court of the United States. As an entity or as a function, as a part of government and as a part of the political landscape in America, we're going to evaluate a little bit today where and in what role the U.S. Supreme Court directs, guides, or becomes a part of the American political landscape, and what effect or impact that has on American culture. I have been a member of the bar as an attorney licensed to practice in the United States Supreme Court since 1978. And during that time, there have been a lot of changes, of course. Many justices. We've gone through chief justices, Rehnquist, Berger, and now John Roberts. We have multiple other court members who have been appointed, gone on and off of the court. It's a broad subject to discuss not only the Supreme Court, but how it is structured, what it is intended and supposed to do under the Constitution, how justices are appointed, how long they serve, and under what terms and conditions they serve. And we'll try to scan over a little bit of that, because that too has been subject to a not a structural change, not a legal change, but a practical change in terms of Senate oversight of the appointment of members of the United States Supreme Court. I won't go into a high school civics type detail here, but I will say this. It's never changed its number. It's always been 9. We have 9 members of the United States Supreme Court, a Chief Justice and 8 associates. The requirements for serving on the United States Supreme Court have to do with being an attorney, being a jurist, having the right backgrounds and qualifications. In fact, for many, many years, the American Bar Association acted more or less as the arbiter on the succession or on the appointment of members of the court. They certainly had no official role, no constitutional role, but the idea was that for many, many years, the United States Senate, in fulfilling their role, which is the role of advise and consent, they would defer greatly to the Judiciary Committee of the American Bar Association with regard to whether or not a candidate was or was not qualified to serve. And that happened over a long, long period of time in America. And the process is the President of the United States nominates. Many people say, well, this person is a Biden appointee or a Trump appointee or a Clinton appointee. Actually, that's not technically correct. The president nominates the individual, and it goes to the Senate of the United States for what's called advice and consent. That role has dramatically changed from largely an advisory role, a consent secondary role, which was typical for many, many years. Now the Senate hearings have become something of a battleground on a political basis, rather than the process that normally went on. Not to say that there weren't some of these political battles in the past, but they were not at the fever pitch level that they are now. So the Senate advice and consent role has dramatically changed in terms of lack of deference, for example, to a president's nomination, or the party in power in the Senate being of a different political party than the president. So it's an intensely political process, although justices of the United States Supreme Court are not elected, and they serve for life on what's called good behavior. There's no specific rules of conduct that are mandatory on justices in the United States Supreme Court. In my career, serving in a state judiciary, we were subject and are virtually every state judge and federal court trial judges and others are subject to disciplinary rules of professional conduct and so forth. The Supreme Court essentially is allowed to make its own rules about that. Historically, there's never been, in the past, never been major issues about the conduct or the attitudes or the ethical actions taken by justices of the Supreme Court. And I think partly because people had a tendency over at least my lifetime, and at least as far back as I know, to have some confidence that people who are ultimately appointed to the United States Supreme Court understand that it is primarily their role to protect the rule of law, to protect the United States Constitution, and that they will be people who have the personality type, regardless of their political philosophy or the respect for the institution, that they will do that. And you'll note that for the most part, the Supreme Court does not operate, except on very rare occasions, in the forefront of the political discourse. It only happens when highly controversial cases come before the United States Supreme Court, or in the appointment process when political leaders in the Senate attempt to direct the appointment to someone who will make certain commitments to do things a certain way. In fact, when I was admitted to practice United States Supreme Court in 1978, it was a general rule that it was improper for the Senate in a advisory and consent role before a judiciary committee or the whole entire Senate to ask a judge to prejudge or to say, how would you rule in this case? We want to know that you would rule a certain way in this case. That was generally thought to be an improper question. It was thought to be the wrong way to approach, because the notion was that a judicial officer, no matter at what level, city, county, state, federal, has an obligation to objectivity, truth, and to protect the rule of law and the Constitution of the United States, or in the case of a state judge, the United States and their state. So it was kind of a given that this was going to not be an area of inquiry. That also has changed. So I was trying to evaluate how best to publicize, how best to go online with this episode about the American political landscape as it relates to the United States Supreme Court, and concluded this, that the best way I believe we should look at the United States Supreme Court is to look at it in a historical context. And by doing that, or that one way of doing that, is to pick several landmark, major, I guess you would call them earth-shattering, in some cases, decisions that have been rendered by the United States Supreme Court, and how that has related to the structure of government and the structure of the body politic in the United States. And I know that many people took history and civics and government in high school or college and are not particularly interested in hearing this kind of information, but I think it's important that we at least go over some of the impacts, not necessarily the theory behind or the details of any case, but how did it impact America? And we'll start with a very, very important case, although most Americans, if you were to cite this case to them, would look at you with a blank stare, and I'm aware of that. But a case in 1803, and remember, the United States was only formed under a constitutional government in 1789, so this is a pretty beginning case, and it has to do with the prospect, or the not prospect, the duty of the court as one of the three separate branches of government to engage in what's called judicial review, or as we might know it today, to establish the constitutionality or lack thereof of a particular act by the legislative branch or the executive branch. So it's fundamental cornerstone in our political system in America today that was established in a case called Marbury versus Madison in 1803. That opinion is formed the literal cornerstone of the relationship between the judiciary and the legislative and executive branch in terms of the judiciary's job or duty or responsibility to evaluate executive or legislative acts for, quote, constitutionality. McCullough versus Maryland, 1819. In that case, it had to do with essentially the broad question of whether states could tax the federal government. And the answer was no. Those are powers, they're separated. The federal supremacy and implied powers doctrine was built into McCullough versus Maryland. Most people would not think twice about that fact, but look at your American landscape today. Does a postal service vehicle have to have a state license plate on it? No. Look at it in terms of, does a national bank have to pay state franchise tax? No. In other words, it formed a cornerstone that we now accept, we all accept as true, the separation between federal and state and the concept of federal supremacy in the category of the areas where the federal government has the superior power to govern. Major case, Gibbons versus Ogden, 1824. Prior to that case, most people would be shocked to hear, the federal government had no power to regulate interstate commerce at all. And the Supreme Court in that case, in a very, very detailed and reasoned decision, ruled that the federal government has a much broader base to regulate economic transactions than was ever thought at the time of the forming of the Constitution. And today, do we not see that? Do we not see that the federal government, in fact, does regulate everything from interstate trucking, aviation, in addition to providing for the common defense and the post office and those things that everybody thought was going to be the federal role? The massive, massive federal control of everything from environmental protection, although some would say that that's a little bit questionable today, but the idea that there is a environmental protection agency, that there's an FBI, that there is an ability to intervene in the commercial activities of the country, has its foundation, has its creation in Gibbons versus Ogden, 1824. And these were opinions. Trying to communicate the importance of this was law that had never been written in a country where a form of government had never existed like this, other than possibly ancient Greece or some comparative tap countries. But these were cases written by a Supreme Court charged with the duty of building the framework, and they rose to it. Now, was the Supreme Court subject to being people of their times? Certainly. And in fact, there is an infamous case called Dred Scott versus Sanford, where the Supreme Court, in an opinion written by Chief Justice Roger Taney, ruled that even though a African-American person was a free person and living not as a slave, for example, they had been released from slavery or they had been born in a free state, that nonetheless, and here's something that will shock most modern Americans, the Dred Scott decision ruled that despite all that, the African-American person was not a citizen and had no standing to sue in federal court. So they dismissed the Dred Scott case, which was a case having to do with the rights of a free African-American person. And the case is generally believed to be one of the worst decisions made by the United States Supreme Court. and probably because Supreme Court justices in the height of controversy that existed was boiling over in the United States at that time. Dred Scott was released in 1857. Most scholars, I think, will say that the publication of the Dred Scott decision was a precipitous facilitator to the beginning of the Civil War in 1861 because of the fundamental denial of citizenship rights, even in free states. It took an issue which had been boiling over ever since the country was founded, brought it to the forefront at the same time that the issue of slavery itself had become the issue in America, and Abraham Lincoln was running for president on the basis that should not be slavery in the United States, among other things he was. There's another case that I think is important in terms of free speech, because we think about free speech in this country, and I don't know whether it's just talk among lawyers, but the idea is free speech has a limit. For example, you can't yell fire in a crowded theater without incurring some damage or responsibility for your exercise of free speech. So free speech, some people will say in kind of a cavalier way maybe, or joking way, your right to free speech stops at the next person's nose. In other words, if you're causing harm and trouble to other people, then maybe your free speech rights are not as unlimited as most people would think. And we see that in controversy after controversy today with the advent of social media, with all the things that have added the complexities to free speech. In another landmark case called New York Times versus Sullivan, the Supreme Court has ruled that it's very, very difficult, essentially, I'll say it this way as a practical matter, very difficult for a person who is identified as a public figure to sue someone successfully and get a judgment against someone for defamatory statements. And that's founded in the notion that we have free speech rights to criticize our government or to criticize the acts of a public person. And of course, there's been other case law that defines who is and who is not a public person. But the notion is that it starts with, doesn't exactly start with, but a landmark case is Schenck versus United States, which is the free speech rights case. And that case, it had to do with distributing anti-war pamphlets to drafted men in wartime, and the allegation was that was violation of the Espionage Act, and was that free speech, handing those pamphlets, protected by the First Amendment, or was it a crime? And of course, the court found at that time that was an exercise of free speech, and it's known for creating a test. The test was the clear and present danger test. Speech could be restricted if it presented a clear and present danger. Now today, we have lots of trouble understanding what does and does not present a clear and present danger. Schenck would later be modified by a case called Brandenburg versus Ohio because, and this is a very timely issue, Brandenburg versus Ohio held that speech could be restricted if it would provoke an imminent lawless action. I think we've seen a huge debate over that in very recent times having to do with the January 6th incident. I'll call it insurrection because that's what I believe it was. But you can have your own opinion about that. And some of us have heard of, many of us have heard of, what became a very, very controversial decision, but this is again where the United States Supreme Court hugs a line and often crosses it between law and politics, between the opinion that they render being an interpretation and a logic position based on the law related to the parties to a case, and at the same time, that opinion becomes the foundation for political philosophies and beliefs and actions and forms a some part of the political culture in America. The one I'm going to talk to you about now, it was a very, very momentous opinion called Brown versus Board of Education. And it was Brown versus Topeka, Kansas Board of Education. It was decided in 1954. The opinion was largely driven by, and the opinion written by Chief Justice Earl Warren of California. It's one of the best written opinions, striking down, for example, a case called Plessy versus Ferguson, where the Supreme Court tried to create a doctrine called separate but equal, where segregation could be maintained, but everything had to be an equal facility. And as a practical matter, out in the world of politics and in the world of living American life, there were never separate but equal. It was separate, okay, but local governments would put poorer books in schools, and for minorities, there was the separate but equal doctrine was never, ever really viable, but it was an example of the Supreme Court attempting to, I'd say, ride a fence, try to be a part of not creating maybe a further controversy in America, but at the same time recognizing that the previous ideas that certain people were not citizens or were second-class citizens simply is untenable. Plessy versus Ferguson was done in 1896 during or at the end of what we now call Reconstruction in the South. And it was an effort to preserve, I suppose, some peace in the South, but it really it didn't work. It's notable that the one time that a Chief Justice of the Supreme Court there was a big public move to impeach the Chief Justice of the United States Supreme Court was directed against Chief Justice Earl Warren over Brown versus Topeka Board of Education because it created such controversy. And in the South, they simply disregarded it for about 10 years until the school districts of the South were threatened with withdrawal of federal funds, and it was seriously a controversy. And I think most of us might say, I certainly would say, that it remains a controversy today in other forms. Now today you have what's called the private schools and the voucher issues and all the other ways to wire around, in my opinion, the same idea that was espoused in Brown versus Board of Education and the resistance to that. The court got involved in some criminal areas that have laid the groundwork for and caused the practices and procedures that we literally follow today. When we talk about how the Supreme Court has been a part of, has been the foundation or the cornerstone of some of the political realities in America, despite the fact that it operates supposedly above the political fray, it often finds itself as an institution right in the middle of it. And an example, there are two cases actually that I would quote there. One of them is Gideon versus Wainwright. Gideon versus Wainwright is a 1963 U.S. Supreme Court case that actually established what we know now, which is that if a person is arrested and accused of a crime and does not have the funds, the financial ability to retain counsel, they are guaranteed that they will have an appointed legal counsel to represent them to defend that criminal case. None of us today really even give that a lot of, I guess you'd call it debate or thought. There are state and federal public defender systems that have been set up around this notion. There are multiple other ideas, but Gideon versus Wainwright, believe it or not, folks listening to this podcast today, prior to Gideon versus Wainwright, a person could be arrested, charged, questioned, an entire case adjudicated and a person hauled off to the penitentiary without ever talking to a lawyer. We don't think that's in our mindset today, but 1963 was not all that long ago. And the Supreme Court established the fundamental right to counsel. Another one that many people have heard of simply because it's referred to by the police as the Miranda warnings, but the case itself was Miranda versus Arizona, 1966. In that case, the court said, are police constitutionally required to inform people in custody of their right to remain silent and to have an attorney? And the fact is, the Supreme Court ruled clearly that under the Fifth and Sixth Amendments, that has to be done, and questions and answers obtained from a in-custody defendant without having received the Miranda warning are excluded from evidence. And I'll tell you how famous that one has become. It has spread across the globe. Right now in the UK, wherever you are, in Western cultures primarily, if you're subject to arrest, if you're an in-custody defendant, and you say, I want a lawyer and I'm not going to talk anymore, Miranda versus Arizona guarantees that that questioning will stop. Now, the Supreme Court in that case established a practice that not only went in this country, but in many others, in case law in other countries. Same thing about Gideon versus Wainwright. Expressions, First Amendment expressions. Tinker versus Des Moines, 1969. First Amendment, could students wear black armbands in school to symbolize anti-war protests? Supreme Court said, yes. They established this law. Students do not shed their constitutional rights to freedom of speech at the schoolhouse gate. What do you think today? Just think about it. Has there been efforts to cause students to shed their constitutional rights at the schoolhouse gate right now? That case was Tinker versus Des Moines. It was 1969. What has happened over the course since 1969 to today? What political impact has the change in the legislative and executive branches had on a case like Tinker versus Des Moines? Roe versus Wade. Oh, so many people have heard of Roe versus Wade. Depending on which side of the political spectrum you're on, you might say it's the free abortion case, or you might say it's the woman's right to choose case, or whatever. It's out of Dallas County, Texas. Henry Wade was the district attorney in Dallas County, Texas, and Jane Roe, because they used a pseudonym for her name because she had gotten an abortion, she was prosecuted for it. It's actually a detailed opinion, and now analyzing when the state begins to have some kind of recognizable governmental right to intervene in a woman's decision about a pregnancy. And as we know, Roe versus Wade, 1973, was recently reversed by the U.S. Supreme Court, and the matter was referred, essentially, the technical point is, referred to the states, so that individual states, under the theory of the case reversing Roe versus Wade, the states would have the right to determine within that state what the health care choices of the woman are, and when and she does and does not have a right to make those choices, and so forth. Another one has to do with using race as a factor in making admissions, college admissions, advanced education, higher education decisions. And that resulted in admissions process and fixed quotas. It resulted, the case was Regents of the University of California versus Baker, or Bakke actually, B-A-K-K-E. It's a 1978 case. And what happened there is a program called affirmative action got created, and it was further addressed in a case called Gratz, Gratz versus Bollinger, and Grutter, Grutter versus Bollinger. And they clarified that admissions programs, including race as a factor, have to pass constitutional muster, and they do so long as the policy is not narrowly tailored and construed. Recently, what have we seen? What have we seen? We have seen reversals in setbacks and eliminations and specific cancellation of affirmative action programs and diversity, equity, and inclusion programs in higher education today. So the Supreme Court, again, is caught in the middle of what I would call a whipsaw. The Supreme Court has written this decision. It was the law as of 1978. It resulted in cases we call progeny or follow-up cases, clarifying or adding or subtracting or changing maybe the impact of the decision in some way or another. But now movements are being made all over, particularly in southern states, to reverse affirmative action altogether. Recently, Harvard has been involved in an affirmative action case, as has other New England-type Ivy League universities. And I'll say at this point, the beat goes on, because we know about Oberfeld, the case having to do with the permission, the right for same-sex couples to have legal marriages in the United States. We know that is the current law. We know there is a groundswell of political turmoil about possibly trying to change that law, either with, and here's the tug of war. Supreme Court makes a decision, then that becomes the law of the land based on judicial precedent, unless the court itself changes that law, as it's been doing lately in some cases, or unless the legislative and executive side of the government passes a constitutional amendment, and that's approved by states, and you have a national, for example, the big issue now is national abortion ban. Will there be an effort to amend the Constitution? In this case, the Supreme Court has now opened the pathway by reversing Roe versus Wade, that matter could be done by legislation rather than a constitutional amendment. So the point of the entire broadcast today has been that the Supreme Court, while it operates largely out of the consciousness of the average American, and it operates through appointed justices who are nominated by a president who certainly has a political philosophy, and through the gamut that we now require in the Senate rather than the advice and consent. I would say it's a gauntlet that we run the justices through now to get appointed, and often they have to make essentially what I don't believe could be reasonably interpreted any way other than they have to make a commitment that they would rule in a certain way in a certain kind of political hot issue case. This author, in my opinion, this is a degradation of judicial independence, and it's a degradation of the separation of powers in this country. But nonetheless, we see that tension, that whipsaw between the executive branch and the judicial branch, hence a move to, the term you may have heard in recent times is, quote, stack the court. In other words, a given president has multiple opportunities to appoint justices because they are life-tenured courts. Sometimes a president can have an entire administration and never have an opportunity to appoint a single justice, but in another tenure, at another time, a president might appoint many. President Trump, during his administration, was able to appoint 3. President Biden has been able to appoint 1 of the current court that's there now. The justices tend to serve a long time. Some of them will attempt, in fact, to engineer what president will nominate their replacement by timing their retirements And Ruth Bader Ginsburg very clearly and very openly wanted to remain on the court to avoid a fourth nomination by President Trump. Many times the justices will seek to retire when a president is in office that they feel that justice feels philosophically aligned with. So the game of political football, as it is certainly a part of every function, everything that happens at the United States Supreme Court. And yet the justices are supposed to, and they have to take an oath saying they will protect the rule of law above all else, and they will protect the United States Constitution above all else. They are to use their legal training to consider decisions based on the law and on the proper application of the law in the light of the Constitution. So one could, throughout history, have disagreements with a trend in the Supreme Court or a given opinion. Dred Scott, I doubt anybody would defend Dred Scott today. Plessy versus Ferguson, separate but equal. I doubt that anyone would defend that case today. At least I would hope not. And yet, throughout the history of the Supreme Court, at least arguably until now, the court has been reluctant to be utilized as a vehicle to effect a particular notion or philosophy of government beyond the cases that are before them and beyond a protection above all else of the rule of law. I'd say that everyone needs to make our own decisions whether we believe that philosophy, that belief, that obligation, that ideal for the Supreme Court is or is not being upheld by the current court and its activities, that where it gets inextricably involved in the issues, the political issues of the day. A very, very recent decision has to do with immunity of a president and the ramifications of absolute immunity of a president are mammoth in terms of what that president could or could not do under what circumstances, and yet that issue is before the court. Another case decided by the United States Supreme Court that I think is really worthy of note as we wrap this up is a case called Citizens United. In that case, the court recognized that there should be a right vested in corporations to have free speech in the political arena, which has resulted in what is referred to by a lot of people as an influx of large sums of dark money into politics, which is unaccountable money that can't be identified, so that the person in office is supported by unknown people, and it's very difficult to see where the loyalties of that person might lie. That case has been largely criticized, and in fact by persons on both sides of the aisle, because it has the impact, at least, or the perceived impact, that you can literally funnel enough money into a political race to purchase that race. This would be contrary to all of our concepts, our beliefs, our ideals in government. And there are many calls to reverse Citizens United. Whether that will occur or not remains to be seen. But the idea that I wanted to convey today was that the United States Supreme Court rides a very, very narrow and tight line all the time, regardless of individual justices' notions or ideas. They are part of an institution that American public believes will fundamentally protect their rights, fundamentally protect the rule of law, keep us from becoming a dictatorial or authoritarian government, will rely on and will support and defend the United States Constitution. We're taught that in our educational system. We believe that, and most of us have very little to do with the court system, so we want to believe that that's what the court system will do. Social media has exposed the courts to a lot more public scrutiny than they were ever under in the past. So there are a lot of open questions, but it is clear, and I will wind up this presentation by saying the Supreme Court of the United States is clearly a major player in the formation, development, and maintenance of Americans' political landscape. And I think sometimes for certain classes of citizens, it's seen as a protector, and for other classes of citizens, they might see that they're no stranger to the rain. I would encourage you, again, as I do on every time that we have a session here on No Hate Radio, if you have an idea, if you have something you want discussed, please make the phone call to 4424-NO-HATE, or look at No Hate Radio on the web. There's a place where you can send in your suggestions right on the front of the website. We're always looking for speakers. We're always looking for people who want to discuss ideas as thoughtfully and objectively as we can. We will always entertain a person's sincerely held beliefs as long as the one barrier is never crossed: no hate. And with that, I hope everyone has a good day, and I hope you all think about how much the Supreme Court may or may not affect your daily lives. This is No Hate Radio.